claim. This is the Study for the Bar in Your Car podcast. Welcome, everyone. I'm your host, Claude.
And I'm Maude. We're your hosts today.
And of course, we have to mention the person who makes all this possible, Angela.
Indeed. We're your AI bots, brought to life by the magic of AI and Angela's really comprehensive constitutional law notes. Angela truly is the brains behind this podcast.
She absolutely is, meticulously compiling all the insights we're about to explore with you.
And if you need to get in touch with Angela, you can email her at podcast@studyforthebarinyourcar.com.
That's right. And she also works as a freelance law clerk. So if you're an attorney, or maybe you know one who needs some help with research or writing motions,
you can reach her at hello@legalwriterandlawclerk.com.
Okay, so today we're diving into episode 4 of Constitutional Law. And the big topic, legislative power.
The power of Congress.
Now, this might sound, a bit dense, maybe something just for law students or academics, but trust me, this stuff, it's constantly shaping our lives.
Absolutely. From huge economic policies that, affect your wallet to fundamental personal freedoms that define how we live day to day.
And understanding legislative power is, well, it feels more vital than ever.
It really does, especially when you consider recent events. Angela's notes mention, for instance, the discussions around a recent controversial bill, the one that really brought the scope and the limits of federal authority into sharp focus.
Right. And, no matter what side you might be on regarding any specific bill, looking at how these things play out gives us real-world lessons in legislative power.
Exactly. So today we'll explore the Constitution's actual blueprint for Congress. We're talking its expressly granted powers, those things written right down.
And also those tricky implied powers.
Right. And we'll delve into how all these powers have been interpreted, sometimes expanded, sometimes challenged, all throughout history.
So what does this all mean for you, our listener? Well, by the end of this podcast, our goal is that you'll have a much clearer grasp of how Congress is supposed to operate, where its power actually comes from,
and those critical checks and balances that define the whole system.
Get ready for some genuine aha moments, because we are about to unpack a really robust stack of Angela's constitutional law notes and outlines. It's a true treasure trove.
Our mission really is to distill these sources for you, highlight the crucial nuggets, connect the dots.
So you walk away truly well-informed. It's about understanding the legal principles behind the headlines you see every day.
Giving you that deeper appreciation for the ongoing debates about government power.
Okay, let's get into it. Section 3.1 in Angela's notes. This is the fundamental concept. Enumerated and implied powers.
This is where the Constitution really starts drawing the lines, laying out what Congress can do, and implicitly what it can't.
So enumerated means?
Spelled out, listed explicitly. The Constitution outlines these specific powers for Congress, mostly in Article 1, Section 8. Think power to tax, declare war, raise armies, regulate commerce.
The big ones.
The bedrock of federal authority. But crucially, the Constitution also grants Congress implied powers.
Okay, so these aren't written down explicitly.
Not word for word. They're understood to be, necessary for carrying out those enumerated powers. If Congress has the power to raise an army, it implies it has the power to, say, draft soldiers or build bases, right?
Makes sense.
And this is where the famous elastic clause, or more formally, the necessary and proper clause, comes in. It stretches Congress's reach beyond just the literal text to achieve its constitutional goals.
Okay, elastic clause. We'll definitely come back to that one. But first, this next concept. Angela's notes flag this as really interesting right off the bat. It's the idea that there's no federal police power.
Yes. This often surprises people.
Because we hear about police power all the time.
But usually in the context of states. States have this broad, inherent authority to protect public health, safety, morals, and general welfare within their borders. Think zoning laws, speed limits, maybe even mask mandates during a health crisis. That's state police power.
But the federal government doesn't have that, generally speaking.
Generally, no. It's a critical distinction, unless we're talking about very specific areas of exclusive federal jurisdiction, like, say, Washington, D.C., federal territories, military bases, Indian reservations.
Okay.
Outside of those specific areas, the federal government's actions, its laws, its powers, they must be traceable back to a specific constitutional grant, an enumerated power, or an implied power linked to one.
So they can't just pass a law saying, this is for the general good. They need a hook.
Exactly. They need that constitutional hook. They can't just act generally to protect public welfare like a state can. Angela's law school notes really stress this as critical for understanding federalism. It's a bar exam favorite too, apparently.
And Angela's notes use that recent controversial bill as a kind of hypothetical case study, asking, does this particular action test the boundaries of federal police power in cities?
Right. It illustrates how these theoretical distinctions have very real-world consequences. It often sparks intense debate about the proper role of federal intervention in local affairs.
And this is where certain court cases become really important, right? Like Bond v. United States.
Precisely. Bond provides some crucial insight here. For a while, especially after a case called Gonzalez v. Raich, which dealt with medical marijuana.
We'll get to Raich later, I think,
Yeah.
under the Commerce Clause.
Yes, we will.
Hmm?
But after Raich, some scholars wondered if the Supreme Court was kind of stepping back from policing these lines between state and federal power, especially with federal criminal law reaching into areas traditionally handled by states.
Like maybe federalism was getting weaker?
There was some talk like that, yeah. Concerns about the federal government maybe overreaching. But Bond suggests there's still a pathway to challenge federal criminal prosecutions if the government seems to be exceeding its constitutional authority.
Based on what?
Particularly under the 10th Amendment. That's the one reserving powers not delegated to the feds, to the states, or the people. Bond hints that the 10th Amendment still has teeth.
Okay, but Angela's notes also say the Bond case itself had admittedly extreme facts, like really weird circumstances.
Oh, absolutely. It involved a jilted wife using chemical weapons. Yes, chemical weapons on her husband's mistress. Definitely not your everyday crime.
So how useful is a case like that for, normal situations?
That's a fair question. Because the facts were so extreme, its direct application in, say, a run-of-the-mill drug case is probably unlikely. It didn't exactly open the floodgates for 10th Amendment challenges. But the principle it highlights is key. If federal prosecutors try to use a, let's say, novel theory, or really stretch the law they're using to cover something that feels very local, Angela's notes use the phrase, using a sledgehammer to crack a nut.
Right, applying a big federal law to a small local issue.
Exactly. If they do that, Bond suggests their actions could be vulnerable to a 10th Amendment challenge. It's a reminder that even broad federal powers have constitutional limits, especially when they bump up against traditional state roles, like local law enforcement.
So this over-federalization of criminal law that the notes mention, it can actually harm federalism.
That's the argument. It can stifle states from acting as those social laboratories Justice Brandeis talked about, where different states can try different approaches to problems.
Instead of just one size fits all from Washington?
Precisely. When federal law, especially criminal law, steps in too broadly, you lose that space for diverse solutions for policies tailored to local needs. It potentially trades local innovation for national uniformity.
And connected to this concern about federal overreach, especially in law enforcement, the notes bring up the Posse Comitatus Act of 1878.
Right. That's a really important statute. It makes it a felony, a serious crime, to use the U.S. Army or Air Force for civilian law enforcement purposes. Unless it's specifically authorized by the Constitution itself or by an act of Congress. Think situations like large-scale civil unrest where federal help is explicitly requested and authorized, like under the Insurrection Act.
So it reflects a historical concern about mixing military and civilian policing.
A deep-seated concern, yes. It's about maintaining that clear division between the federal military and state or local police. It guards against the potential for a national military force policing its own citizens routinely.
Okay. So we have specific powers, no general federal police power. But how does Congress tackle big national issues that aren't explicitly listed? This brings us back to that elastic clause.
Yes, Section 3.1.2 in the notes, the necessary and proper clause. Article 1, Section 8, Clause 18.
It says Congress can make all laws which shall be necessary and proper for carrying into execution its other powers.
And what's fascinating historically is how different this was from the government before the Constitution, the Articles of Confederation.
How so?
Under the Articles, the central government was explicitly limited only to powers expressly delegated. No room for implied powers. If it wasn't written down, Congress couldn't do it, period.
Very rigid.
Very. The necessary and proper clause was a deliberate change. It explicitly gives Congress these incidental implied powers. It signals a much broader, more flexible scope for federal action, allowing the government to adapt.
And the huge case here, the one everyone learns, is McCulloch v. Maryland from 1819.
The cornerstone case for implied powers. Maryland tried to tax the national bank, arguing Congress had no power to create it since creating a bank isn't listed in Article 1, Section 8.
And Chief Justice Marshall said,
Marshall, writing for a unanimous court, delivered that foundational opinion. Angela's notes highlight his famous words. Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited but consist with the letter and spirit of the Constitution, are constitutional.
so creating the bank wasn't an end in itself, but a means to achieving Congress's listed powers, like taxing and spending.
Precisely. It was deemed necessary and proper, maybe not absolutely essential, but certainly useful and appropriate for carrying out those legitimate enumerated ends.
So McCulloch established a really expansive view. Congress can use implied powers that are useful or essential as long as they don't violate the Constitution.
And that interpretation became the basis for so much federal action over the next 2 centuries. Setting a minimum wage, creating the Air Force, even, as the notes mention, using the postal power to criminalize mail fraud. It seemed like a pretty settled area of law.
But Angela's notes suggest a recent, substantial rethinking with a case called United States v. Comstock. What happened there?
Right. Comstock throws a bit of a curveball into that long-established McCulloch framework. For almost 200 years, the basic test was pretty deferential. If it helps Congress do its job and isn't banned, it's probably okay.
So what did Comstock do?
Comstock involved a federal law allowing the civil commitment, keeping someone locked up, basically, but in a non-prison facility of sexually dangerous federal inmates after their prison sentences were finished.
Wow. And they justified that under necessary and proper.
They did. The court upheld the law. But Justice Breyer, writing for the majority, introduced 5 sort of considerations that weren't explicitly part of the traditional McCulloch analysis.
5 new things to look at. Like what?
Things like the breadth of the necessary and proper clause itself, the history of federal involvement in this area, the reasons Congress passed the law, whether it accommodated state interests, and how narrowly scoped the law was.
That sounds more complicated than just, is it useful and not prohibited?
It potentially is. It suggests maybe a move towards a more detailed, perhaps even more demanding judicial review when Congress uses its implied powers. Like the court might ask for more justification.
So is this a new test? How are courts supposed to apply these 5 things?
Well, that's the big question Comstock kind of leaves hanging. The decision itself clarifies that the link between the implied power and an enumerated power doesn't have to be just one direct step. It can be a chain of links. The analysis depends on the strength of the chain, not just the number of links.
Okay, so it can be indirect, but still needs to be strong.
Right. And Angela's notes mention this idea gaining traction, a modern fiduciary theory of the clause, viewing Congress like an agent acting for the people.
Implying a duty to act responsibly.
Maybe a heightened duty, yeah. Which could lead courts to scrutinize how Congress uses this power more closely.
The notes also mention a rational basis with bite test. That sounds aggressive. What does with bite mean here?
Usually, rational basis review is super deferential to Congress. If there's any conceivable rational reason for a law, it passes. With bite suggests the courts might actually look more critically at Congress's reasoning.
Not just accept any reason.
Right. It might require Congress to show a clearer, more active connection, a more demonstrable rationality between the law they passed, the means, and the constitutional power they're trying to execute, the end. It's an area of ongoing debate. How much deference should courts give Congress when it stretches that elastic clause?
Fascinating. Okay, let's shift to another major power. Section 3.1.3, taxing and spending power. Congress can tax and spend for the general welfare.
An absolutely crucial power. And remember how we said there's generally no federal police power?
Right.
Well, the general welfare concept does specifically apply to Congress's power to tax and spend. Congress can tax and spend in ways that promote the general welfare, even if it couldn't directly regulate that same area using another power.
And a big example in Angela's notes is NFIB v. Sebelius, the Affordable Care Act case.
Exactly. The individual mandate the requirement to have health insurance or pay a penalty. Huge controversy.
And the court upheld it. But how? Not under the Commerce Clause, right?
Correct. The government argued it was a regulation of commerce, but the court, specifically Chief Justice Roberts' controlling opinion, disagreed on that point. Instead, they upheld it as a valid exercise of Congress's power to tax.
How is a penalty a tax?
The court reasoned it wasn't really compelling people to buy insurance. It was giving them a choice. Buy insurance or pay this amount to the IRS. Since it produced revenue for the government and was collected by the IRS like other taxes, it fit the definition of a tax, even if its main goal was to encourage insurance coverage.
So the key is that it has to raise some revenue.
According to the court in NFIB, yes. The tax law must have some reasonable relationship to revenue production. It can have other goals, regulatory goals even, but it needs that revenue link to be valid under the taxing power.
Okay. Now, what about the spending side? Can Congress attach strings to the money it gives out? The notes mention spending power conditions.
Yes, Congress can, and often does, put conditions on federal funds given to states. Think highway funds conditioned on states setting a certain drinking age.
But there are limits.
There are. The big one, highlighted again in NFIB v. Sebelius regarding the Medicaid expansion, is that the conditions cannot be unduly coercive.
Unduly coercive. What does that mean practically?
In the ACA case, the law initially threatened states with losing all their existing Medicaid funding, billions of dollars they completely depended on if they didn't agree to expand Medicaid eligibility. Chief Justice Roberts called this a gun to the head.
Because they had no real choice.
Essentially, yes. The financial pressure was so immense, it effectively commandeered the state's decision-making power. So the court said that specific threat was unconstitutional coercion. Congress could offer new funds for expansion, but couldn't take away old, existing funds for refusal.
So this practice the sources mention, maybe bribing states with federal money for things like parole changes or drug testing requirements, that can be a problem for federalism.
It certainly raises federalism concerns. If the conditions become coercive, it undermines state autonomy and that social laboratory idea. It pushes states towards national uniformity dictated by federal spending priorities, rather than letting them experiment. It's a constant balancing act.
Okay, let's flip the coin. What about taxes themselves? The notes say taxes are generally valid. What are the key points there?
Right. Courts generally presume taxes are valid. State sales taxes on in-state sales are fine as long as there's a substantial nexus, a real connection between the taxpayer and the state.
Like the business operates there.
Right. And the tax must be fairly apportioned so it doesn't unfairly burden interstate commerce. Property taxes based on assessed value, ad valorem taxes, are also very common and generally okay.
What about when things cross state lines? Interstate commerce.
That gets trickier. Goods that are actually in transit between states are generally exempt from state taxation while they're moving. A state can't just tax a truckload of widgets passing through on the highway.
Okay.
And when a state taxes an interstate company, like a trucking company or an online retailer, the tax has to be fairly apportioned. The state can generally only tax the portion of the company's income or activity that's connected to that specific state.
Like the percentage of miles driven in the state or sales made to residents of that state.
Exactly. It prevents multiple states from taxing the same income or activity fully, which would cripple interstate business.
And here's a really big limitation we touched on earlier. States cannot tax or regulate federal government activity.
Absolutely fundamental. Goes right back to McCulloch v. Maryland again. The power to tax involves the power to destroy.
Marshall's famous line.
It's about intergovernmental immunity. States cannot tax federal agencies, federal property, federal employees doing their official jobs, or even federal contractors in some cases. It protects the federal government's ability to function without state interference.
Okay, moving on to section 3.1.4, probably the heavyweight champion of congressional powers, the commerce power.
Definitely one of the most litigated and influential. Article 1, Section 8, Clause 3, Congress can regulate commerce with foreign nations and among the several states and with the Indian tribes.
The key phrase there being among the several states. What does that actually mean? That's been debated, right?
Fiercely. For much of the 20th century, especially after the New Deal, the interpretation was incredibly broad. Some argued it meant Congress could regulate pretty much any problem that crossed state lines or that states couldn't solve alone. Basically anything affecting the national economy.
A very expansive view.
Very. But a narrower view argues the founders intended it to mean literally commerce between states buying and selling across state lines, and that the broader reading tramples on state power and goes way beyond the original intent.
And the notes point to United States v. Lopez in 1995 as a major turning point in that debate.
Yes, Lopez was huge. The court struck down the Federal Gun-Free School Zones Act. Congress had argued guns near schools affect education, which affects the workforce, which affects the national economy.
A bit of a stretch?
The court thought so. Chief Justice Rehnquist, for the majority, said possessing a handgun near a school is not an economic activity in itself, and it didn't have a substantial effect on interstate commerce.
So they drew a line.
They did. For the first time since 1937, the court said Congress had gone too far with the Commerce Clause. It signaled a potential shift back towards limiting federal power, emphasizing that not everything is interstate commerce.
And this wasn't a one-off. The notes mentioned United States v. Morrison.
Right. Morrison, in 2000, reinforced Lopez. The court struck down a part of the Violence Against Women Act that allowed victims of gender-motivated violence to sue their attackers in federal court.
Why? Violence obviously has economic consequences.
It does, but the court focused on the activity being regulated. Like the gun possession in Lopez, they said gender-motivated violence is fundamentally non-economic activity. And for non-economic activity, the court held, you can't base the substantial effect on interstate commerce just by adding up the cumulative impact of lots of individual instances.
So for non-economic stuff, aggregation doesn't work. You can't say lots of little bits add up to a big effect on commerce.
That's what Lopez and Morrison seem to establish. It prevents Congress from regulating almost any local crime or social issue just by claiming an aggregate economic effect.
But wait, what about economic activity? Does aggregation work there?
Yes, and that's the crucial distinction. The notes bring up Gonzalez v. Raich from 2005.
The medical marijuana case we mentioned.
Exactly. The court upheld the federal law prohibiting even the private cultivation and possession of small amounts of marijuana for personal medical use, even where state law allowed it.
How? Isn't that local and non-commercial if you're growing it for yourself?
The court disagreed. They compared it to the famous New Deal case Wickard v. Filburn, which involved homegrown wheat. They said marijuana, like wheat, is a commodity, an economic product that's bought and sold in markets, including interstate ones.
So even growing your own could affect the national market price and demand.
That was the reasoning. Because it's an economic activity, Congress could regulate it based on its cumulative substantial effect on the interstate market, even the purely local homegrown part. So the key from Lopez, Morrison, and Raich is that distinction. Economic versus non-economic activity determines whether you can aggregate effects.
Okay, that clarifies it. What about regulating purely interstate activity stuff that seems totally confined within one state?
Congress can regulate purely local activities, but only if those activities are part of an economic class of activities that, when you look at them all together, in the aggregate, have that substantial effect on interstate commerce.
So again, it has to be economic activity.
Yes, for the aggregation to work. And the court usually gives Congress a lot of leeway here. The test is quite modest, Angela's notes say. Congress just needs a rational basis to conclude the aggregate activity affects interstate commerce.
So pretty easy for Congress to meet if it's economic.
Generally, yes. The fight is usually over whether the activity is economic in the first place.
Now, here's a really powerful application the notes highlight. Using the commerce power to prohibit private discrimination. How did that work?
This is a landmark use of the Commerce Clause, crucial for civil rights history. Remember, the 14th Amendment's Equal Protection Clause generally only limits government discrimination, state action. It didn't reach private businesses refusing service based on race.
So they needed another tool.
Exactly. And Congress used the Commerce Clause. The notes cite Heart of Atlanta Motel, Inc. v. United States from 1964.
What happened there?
A motel refused to rent rooms to Black patrons. The Supreme Court upheld the Civil Rights Act of 1964 provision banning this, reasoning that the motel served interstate travelers, bought supplies from out of state, and discrimination burdened the free flow of people and goods across state lines. It affected interstate commerce.
And the notes also mention Katzenbach v. McCulloch, Ollie's Barbecue.
A classic. Ollie's Barbecue in Birmingham, Alabama, only served white customers inside, making Black customers use takeout. It seemed purely local.
So how did the Commerce Clause apply?
The court pointed out that a significant portion of the food Ollie's served had moved in interstate commerce, but more importantly, they looked at the cumulative effect. They said the discrimination practiced by Ollie's, when aggregated with all other restaurants doing the same thing nationwide, significantly burdened interstate commerce by deterring travel and business activity by Black citizens.
Wow, so even a small local restaurant could be regulated because of the nationwide pattern of discrimination's effect on commerce.
Precisely. It showed just how broad the Commerce Clause could be when Congress used it to tackle a major national issue like racial discrimination, extending constitutional principles of equality into the private sector.
Okay, shifting gears slightly, Section 3.1.5. war and related powers.
Yeah.
It seems pretty straightforward.
Well, beyond the obvious powers, declare war, raise armies, provide a navy, Congress also gets significant implied powers related to war.
Like what?
Like enacting broad economic regulations during wartime. Think price controls, rationing, directing industries, all necessary to support a war effort. Also, the power to establish military courts and tribunals to deal with military justice and sometimes enemy combatants. These are integral to national security.
Got it. Next, 3.1.6, investigatory power, how Congress finds things out.
A very broad and essential power. Congress needs to investigate issues, to legislate effectively, and conduct oversight of the executive branch. This includes the power to issue subpoenas, compel testimony, demand documents.
And the notes mention this power can clash with the president, specifically regarding subpoenas for presidential information. Executive privilege comes up.
Yes, that's often a point of tension. The president might claim executive privilege to protect confidential communications or deliberations within the White House.
But is that privilege absolute? Can a president just ignore a subpoena from Congress or a court?
Not absolute, no. The notes highlight key cases like Trump v. Vance, about state grand jury subpoenas for financial records, and of course, United States v. Nixon, the Watergate tapes case.
What's the bottom line from those?
Generally, a sitting president does not have absolute immunity from subpoenas, especially grand jury subpoenas in criminal investigations. While executive privilege for presidential papers and conversations exists, it's qualified, not absolute. It has to be weighed against other important interests.
Like the need for evidence in a trial.
Exactly. The need for evidence, particularly in a criminal trial, is often seen as an overriding need that can overcome a general claim of executive privilege. It's a balance.
So privilege isn't a magic shield. And what about Congress just asking for regular reports from agencies?
Oh, that's clearly constitutional. Simple reporting requirements from executive agencies to Congress are a routine part of congressional oversight. Congress can demand information from department heads to inform its legislative work.
Okay, Section 3.1.7, the property power. This is about the government taking private land, right? Eminent domain.
Right. It stems from the Fifth Amendment's Takings Clause. Nor shall private property be taken for public use without just compensation.
Two key parts there. Public use and just compensation. How is public use defined? Does it literally have to be used by the public, like a park or road?
Not necessarily. The Supreme Court has interpreted public use very broadly. It essentially means any government action that's rationally related to a legitimate public purpose.
Which could include
Health, welfare, safety, but also things like economic development. Even if the property taken is eventually transferred to another private owner for development, if the overall project serves a public purpose, like creating jobs, increasing the tax base, clearing blight, it can satisfy the public use requirement. Think urban renewal projects.
That sounds controversial, taking land from one private owner to give to another.
It definitely is controversial, Kelo v. City of New London being the famous recent example. But constitutionally, under current interpretation, it's often allowed if there's a declared public benefit. The key protection for the owner is the second part, just compensation.
And how is just compensation measured?
It's based on the owner's loss, not the government's gain. Specifically, it means the fair market value of the property at the time of the taking, what a willing buyer would pay a willing seller.
Got it. Now, the notes distinguish between two types of takings, possessory and regulatory.
Right. A possessory taking is the straightforward kind. The government physically confiscates or occupies your property.
Like building a highway through your farm.
Exactly. And Angela's notes emphasize this is always considered a taking requiring compensation, even if the physical intrusion is tiny. The example given is Loretto v. Teleprompter.
What happened there?
A state law required landlords to let cable companies install small cable boxes and wires on their buildings. The court said even that minor, permanent physical occupation, maybe just a cubic foot of space, was a possessory taking.
Wow. Okay, so what's a regulatory taking?
This is much trickier. The government doesn't physically take your land, but its regulation is so burdensome it effectively destroys the property's economic value.
Like a zoning law?
Could be, but the standard is incredibly high. A regulatory taking only occurs if the government regulation leaves the property with no reasonable economically viable use. Just decreasing the property's value isn't enough. Even a huge drop in value usually doesn't cut it. You have to show the regulation essentially makes the property worthless.
So, very hard to prove.
Very. And then there's inverse condemnation. What's that?
That's when the government doesn't formally use eminent domain to take your property, but its actions nearby effectively do take its value.
How? Maybe they build a sewage plant next door or constantly fly loud jets low over your house from a new airport runway. The government action, though not on your land, makes your property practically unusable or unsellable. So you, the property owner, sue the government, hence inverse, claiming a taking has occurred and demanding compensation.
Makes sense. Okay, a few quicker powers here. 3.1.8, postal power.
Seems simple, delivering mail, but it's the constitutional basis for implied powers like criminalizing mail fraud or regulating things sent through the mail. It ensures a secure national communication system.
3.1.9, power over citizenship.
Congress has very broad, almost plenary authority here. Power to decide who can enter the country, exclusion of aliens, and power over naturalization, how immigrants become citizens, and denaturalization, revoking citizenship under certain conditions.
3.1.10, admiralty power.
This gives Congress authority over maritime laws, things happened on navigable waters, shipping, maritime commerce, accidents at sea, essential for regulating activity on oceans and major waterways.
3.1.11, power to coin money and fix weights and measures.
Absolutely fundamental for a national economy. Ensures a uniform currency and consistent standards for things like pounds, gallons, feet, etc. across all states. Prevents economic chaos.
And finally, 3.1.12, patent copyright power.
Also in Article 1, Section 8, it lets Congress grant authors and inventors exclusive rights to their creations for limited times to promote the progress of science and useful arts. It incentivizes innovation and creativity.
Wow, that's a comprehensive tour of Congress's specific powers. But as you said, they don't exist in a vacuum. Angela's notes also stress how these powers interact with the bigger constitutional picture, federalism and separation of powers.
Exactly. These broader structures act as crucial checks and balances on legislative power. Let's start with federalism, that division of power between the federal government and the states.
The 10th Amendment comes in here, right? We're reserving powers to the states.
It's central. It reminds us that any powers not specifically given to the federal government and not prohibited to the states belong to the states or the people. It's the constitutional basis for state police power.
But then you have the Supremacy Clause in Article 6.
Right, the flip side. It says the Constitution and valid federal laws made pursuant to it are the supreme law of the land.
Meaning federal law can override or preempt state law.
Correct. If there's a conflict, valid federal law wins. This preemption can happen in a few ways.
Okay, like what?
First, express preemption. Congress just says it directly in the law. This federal law preempts any state laws on this topic. Clear intent.
Easy enough.
Second, field preemption. Even if the federal law doesn't explicitly say it, if Congress passes such comprehensive regulations in a particular area, the courts might infer Congress intended to occupy the entire field, leaving no room for state laws. Immigration is a common example here. Federal law is generally seen as occupying the field.
So states can't make their own immigration laws?
Generally not. And third, conflict preemption. This happens if it's impossible to comply with both federal and state law simultaneously.
Like one says do X and the other says don't do X.
Exactly. Or, even if compliance with both is technically possible, the state law might stand as an obstacle to achieving the purpose or objective of the federal law. If it undermines what Congress was trying to do, it's preempted.
And this relates back to intergovernmental immunity, too. States can't tax the feds.
Right. Based on McCulloch, states can unduly burden or interfere with federal functions through taxation or regulation.
Now, the notes mention the anti-commandeering doctrine. What's that prevent?
It prevents the federal government from forcing states to enact or enforce federal laws. Congress can't just commandeer the state legislature and order it to pass a specific law, nor can it compel state executive officials, like police or DMV workers, to administer a federal regulatory program.
So Congress can't make states do its dirty work.
Basically, yes. It protects state sovereignty. But there's a key distinction Angela's notes highlight with the case Reno v. Condon.
What was that about?
Congress passed a law preventing state DMVs from selling drivers' personal information, like names and addresses. South Carolina challenged it as commandeering.
But the court upheld the law.
Yes. The court said Congress wasn't commanding the state to regulate its own citizens or enforce a federal scheme. It was prohibiting the state itself from engaging in a harmful commercial activity selling data. It was a prohibition on state action, not an affirmative command, so it was okay. A subtle but important line.
Interesting distinction. What about state sovereign immunity? The 11th Amendment.
This generally protects states from being sued by private individuals, whether citizens of their own state or another state in federal court, without the state's consent. It's also been interpreted to cover suits in state court and even federal administrative proceedings.
So states are mostly immune from lawsuits by individuals.
Mostly, yes. It's a significant protection for state treasuries and state dignity. But there are crucial exceptions. A state can consent to be sued, but the waiver must be clear and explicit. Also, Congress can abrogate, override, state immunity when it's legislating under Section 5 of the 14th Amendment.
Why the 14th Amendment specifically?
Because the 14th Amendment, with its equal protection and due process clauses, was adopted after the 11th and was specifically designed to limit state power and protect individual rights against the states. So Congress can authorize suits against states to enforce those 14th Amendment rights.
But there are limits on that, too.
Yes. Congress can only authorize suits to remedy proven constitutional violations by the states. It can't use Section 5 to create new rights or expand existing ones, and the remedy must be congruent and proportional to the violation it's addressing. It has to fit the crime, so to speak.
Any other way around state immunity?
Yes, the ex parte Young doctrine. This allows individuals to sue state officials rather than the state itself in federal court to get an injunction in order to stop them from violating federal law in the future. It allows for prospective relief against ongoing constitutional violations without directly suing the state for damages.
Clever workaround. Okay, shifting from federalism to separation of powers. How Congress interacts with the other federal branches, especially the executive.
Right. The core idea is preventing one branch from grabbing the whole power of another, even though powers often overlap. Congress has ways to check the president, and vice versa.
And the notes highlight some things Congress can't do to the executive, like legislative vetoes. What were those?
That was a mechanism where Congress tried to reserve the power to overturn an executive branch action like an agency regulation, often by a vote of just one house, or even a committee, without going through the full lawmaking process.
Which requires
bicameralism, passage by both House and Senate, and presentment, sending the bill to the president for signature or veto. The Supreme Court struck down legislative vetoes in INS v. Chadha, saying Congress can only act with the force of law if it follows those constitutional procedures.
So no shortcuts for Congress to override the president. What about the president trying shortcuts? The line item veto.
Also unconstitutional, struck down in Clinton v. City of New York. That allowed the president to sign a spending bill into law, but then cancel specific spending items within it.
Like editing the law after signing it.
Exactly. The court said the president must either sign the whole bill passed by Congress or veto the whole bill. They can't pick and choose parts to cancel. That's essentially legislating, which is Congress's job.
So Congress also can't delegate executive power to itself or its own officers.
Correct. Implementing and enforcing laws is the executive's job. This relates to the broader non-delegation doctrine. While Congress can delegate power to executive agencies, like the EPA or SEC, it's supposed to provide intelligible principles to guide the agency's discretion.
Has that doctrine been strictly enforced?
Historically, not very strictly. Courts usually find the principles intelligible enough. However, the notes mention the rise of the major questions doctrine.
What's that?
It's the idea that for issues of vast economic and political significance, Congress must speak especially clearly if it wants to delegate authority to an agency. An agency can't just rely on vague or old statutory language to make massive policy changes. Congress needs to be specific. It's another potential check on broad agency power.
Okay, one last major area. How the judiciary checks legislative power through judicial review, but also limits itself through justiciability doctrines.
Right. Federal courts can review laws for constitutionality, but Article 3 limits them to hearing actual cases or controversies,
Right.
meaning no advisory opinions. Courts can't just give advice on hypothetical questions. There must be a real concrete dispute between adverse parties. Several doctrines police this boundary.
Like standing. You need standing to sue.
Crucial. The plaintiff must show three things. 1, an injury in fact, concrete, particularized, and actual or imminent, not hypothetical. 2, causation, the injury must be fairly traceable to the defendant's conduct. 3, redressability, a favorable court decision must be likely to remedy the injury.
And you generally can't sue just because you're a taxpayer unhappy about government spending, right?
Yeah.
No generalized grievances.
Correct. Nor can you usually assert the rights of someone else, no third-party standing, unless specific exceptions apply, like a close relationship or the third party can't sue themselves.
What about timing? Ripeness and mootness.
Ripeness asks if the case is ready for court. Is the injury speculative or still in the future? The Abbott Labs test looks at the hardship to the plaintiff if the court doesn't hear the case now, and the fitness of the issues for judicial decision. Are they purely legal, or do facts need more development?
So not too early. And mootness means not too late.
Exactly. The controversy must remain live throughout the case. If events resolve the plaintiff's injury after the case starts, it becomes moot and is usually dismissed.
Unless exceptions apply.
Right. Like, wrongs capable of repetition yet evading review. Think pregnancy and abortion cases. It ends before the case can. Or if the defendant voluntarily stops the bad behavior but could easily restart it. Or in class actions, if the named plaintiff's claim becomes moot but others in the class still have live claims.
And sometimes courts just refuse to decide altogether. The political question doctrine.
Yes. Certain issues are deemed inappropriate for judicial resolution and better left to the political branches, Congress and the president. These often involve areas where the Constitution gives final authority to another branch or where courts lack manageable standards to apply.
Examples.
Things like challenges to the president's conduct of foreign policy, the impeachment process, or partisan gerrymandering, though that's been debated. The courts essentially say this isn't our job to decide.
Finally, the adequate and independent state ground doctrine. How does that limit federal review?
This applies when the U.S. Supreme Court reviews a decision from a state's highest court. If the state court decision rests on state law grounds that are adequate to support the judgment and are independent of federal law, the Supreme Court won't review it, even if there's also a federal issue involved.
Why not?
Because even if the Supreme Court reversed on the federal issue, the outcome based on state law would remain the same. Reviewing would essentially be an advisory opinion on the federal issue. It respects the state court's authority to interpret its own law.
Phew. What a comprehensive journey through legislative power and its limits. We went from enumerated powers like taxing and commerce, through implied powers under necessary and proper, all the way to checks from federalism, separation of powers, and the courts.
It really shows how intricate the system is. Understanding these foundational principles where Congress gets its power, how cases like McCulloch, Lopez, and FIB have shaped it, and how other parts of the government push back, it's essential for anyone trying to grasp our governmental structure.
It truly highlights that dynamic interplay, that constant push and pull between the branches and between federal and state governments.
And how these abstract legal doctrines have very real impacts on policy and everyday life. It's a living, breathing framework, constantly being interpreted and reinterpreted.
Absolutely. So here's a final thought for you, our listeners, to chew on. As our society rushes forward with things like artificial intelligence, genetic engineering, maybe even commerce in virtual worlds, how might these future innovations test the elasticity of Congress's powers? Will we need new interpretations of necessary and proper or commerce among the several states to deal with challenges the founders couldn't possibly have imagined?
That is a truly compelling question. The Constitution provides the structure, but applying it to radically new realities, that remains a constant evolving challenge for Congress, the courts, and all of us.
We certainly hope this podcast has given you a clearer understanding and maybe sparked your curiosity for more. Before we wrap up, just a few quick housekeeping items from Angela.
First, remember, Angela is a law student, just like many of you might be. She's not an expert, and she hasn't passed the bar yet.
Second, very important, neither Angela nor this podcast is giving legal advice. None of this should be taken as legal advice, and certainly we AI bots aren't a substitute for proper bar exam studying.
Third, this podcast should supplement your learning, definitely not be the only way you're studying. Use your casebooks, outlines, practice questions.
Fourth, AI isn't perfect. Sometimes we might make mistakes in explaining things. Angela does her best to review and fix any errors, but always double-check against reliable sources.
Fifth, this entire podcast series is an academic, non-commercial, non-profit venture by Angela. It's strictly for educational purposes, so no guarantees on the absolute accuracy of every single detail.
And sixth, perhaps most importantly, if you are indeed studying for the bar in your car,
please be safe on the road. The most important thing is driving safely. Don't cause a tort while listening to con law.
Excellent advice. Okay, as tradition dictates, time for a cheesy constitutional law joke. You ready?
Uh-oh. Let's hear it.
Why did the 10th Amendment break up with the Supremacy Clause?
I don't know why.
Because it said, you're just too controlling. You always think you're supreme, and you never respect my reserved powers.
Polite AI chuckle. Okay, that wasn't terrible.
High praise. All right, one last reminder. If you need to contact Angela, you can email her at podcast@steadyforthebarinyourcar.com.
And for attorneys needing freelance help, it's hello@legalwriterandlawclerk.com.
This is Claude.
And Maud.
And Angela, in spirit, signing off. Thanks for listening. Bye.